Hi, I'm John Strohmeyer, and today we're talking about declarations of guardian for your minor children. Now, a lot of clients come to me and think that they use their last wills as a place to name the guardians for their children if something happens to them. Now, this can be done, and Texas law does allow for it, but generally we're going to be using a separate document outside of the last will for that purpose. Well, what are we doing? We want to think about the two types of guardianship that we can name for our minor children, as well as why we're doing it in a separate document. One, we'll use a separate document to make sure that even if the parent hasn't died, but they're just incapacitated, we still have a separate document that will be used to monitor or to determine who those guardians are. It's also a shorter document that doesn't require that we list out everything in the person's last will as part of any sort of probate proceeding. So who are the people we're going to be naming? Well, we look at naming two types of guardian. First, we're going to name a guardian of our children's person, and then we're going to name a guardian of the children's estate. We can name the same person for both jobs, or we can name two separate people. What we can't do is name two or more people as co-guardians if they're not married to each other. A lot of this comes down to the Texas courts don't want to have to deal with multiple parties pointing fingers at each other. If somebody's going to be in charge, they want one person to point that finger at and not have to say, well, these two brothers are guardian for the third deceased brother's child. Which one is in charge? They want to look at one person who's responsible. So I mentioned two types of guardians. The first one is going to be the guardian of the person. The guardian of the person is going to be responsible for the food, clothing, and sheltering of those minor children until they reach age 18. So in many cases, this is going to be who that minor child lives with. It's just going to be easier for them to live with that person and for that guardian of the person to make those decisions. It's not a requirement, though. It may be something, you may have children who are at boarding school and therefore the guardian of the person doesn't actually live with them. The second type of guardian we want to think about is the guardian of the estate. Now, the guardian of the estate may get set up if somebody has left property to a minor, and a person under 18 under Texas law is not allowed to own property legally. So who owns that? Well, in cases where we're giving some small amount of cash to a child, that's not something where we'd set up a guardianship. But if a child were set to receive an inheritance from a parent or a grandparent of a substantial amount, this is a situation where if there's not a trust involved, we'd have to set up a guardianship for that child because somebody has to legally own the property for them. Now, the guardian of the estate then steps in to take over and own the assets on behalf of the child. They'll be responsible for reporting to the probate court what happened to the property, if any of the assets subject to the guardianship have been used and where they've been used, and ultimately make sure that the guardian hasn't taken those assets and used them for themselves. So parents of minor children would use this declaration of guardian for their minor children to name not only who would be the person who helps raise their child, but also if there's any assets for their child, who would manage those assets. So you could split those duties between the family member who'd be better at raising them and as the guardian of the person, and the family member who would be better at managing property for them as the guardian of their estate.